Well, I don't know. I mean, it seems to me you're asking us to do something very unusual here, which is to take a statute which does create a cause of action and a cause of action directly against foreign sovereigns, but to say that just because you've created a cause of action against foreign sovereigns, you're also abrogating immunity when you know that there's a Foreign Sovereign Immunities Act that is in charge of the immunity question, if you will. And it raises the question, this is not a magic words test. It's like it could have done it in 1,000 different ways, but why didn't, rather than this very peculiar, reference to 1331, which it's pretty unclear what it means, but why didn't Congress just say, like, we're displacing the FSIA with respect to this, or we're abrogating sovereign immunity, or just give some indication that that's what it meant to do, other than create a cause of action, which is a completely different question in the foreign sovereign immunity context?
I think that it did both. I just have to go back to what I said in my intro, what I just said in response to Justice Sotomayor. I think the only way to read 6082 C1 and C2 is to say that Congress here was speaking to questions of subject matter and personal jurisdiction with respect to foreign sovereigns, and that's the reason. I mean, if they wanted it to just be about other defendants, like the cruise lines, then they don't need to be. So
you're really saying it really hinges on those two little.
Those are the best indications we have that Congress is actually talking about it in the jurisdictional sense.
So you're not making a
but
point
we have
about,
all the other confirmatory provisions that my friend is relying on.
You're not saying, like Kurtz definitely controls this because whenever you have a cause of action against a government, that answers your question. You're not saying that.
That is correct. I think we're asking for Kurtz plus. We think that the cause of action language, I don't want to minimize the importance of it. I think that the fact that the 1996 Congress used the same words that were able to waive federal sovereign immunity when they were talking about foreign instrumentalities and agencies, I think that is a compelling indication. But I think here it is important that we also have specific references to Cuban government agencies and instrumentalities all over the statute, and we have these provisions talking about what I'm calling an ouster of the jurisdictional portion of the FSIA.
If I could take you back to Justice Alito's question, and let's assume that I think that this execution immunity provisions in the FSIA really continue, that there's no reason to think that they didn't continue on. And indeed, the fact that this statute amended them a little bit makes clear that Congress thought that they were going to continue. So then the point is then what you're asking us to do is to read the statute in a highly unusual way in order to abrogate sovereign immunity in cases in which, even putting aside the practical issues that Justice Alito was talking about, there are legal bars to collecting on your judgment against a foreign sovereign. So, why would Congress have done that?
You could ask the same thing with respect to other parts of the FSIA's immunity exceptions that aren't echoed in the attachment exceptions. And as the court said in NML Capital, it's a smaller set of exceptions for its execution and attachment immunity than it is for jurisdictional immunity. And since then, the mismatch has actually grown. 1605 capital B, a new provision that Congress added in 2016, literally has no parallel in execution immunity. And so you have a waiver of jurisdictional immunity with respect to acts of international terror in the United States, and there's no corresponding waiver on attachment and execution immunity. And
so I guess one aspect of this is if sort of the thrust of the argument, and I know you're trying to hook it into these technical provisions, but if a thrust of the argument is Congress was really concerned about this problem and it really wanted to go after these agencies and instrumentalities because weren't they the ultimate bad guys here? I mean, if that's really what Congress was trying to do, it proceeded in a very odd fashion because you're not going to get anything from them anyway, given that the execution immunity exists.
But take out the execution immunity. There's still going to be
take it out. That was the question.
Well, no, but my point, Justice Kagan, was going to be back to what you alluded to, I thought, as the practical considerations that Justice Alito raised, which is that Congress knew there were not going to be very many Cuban assets in the United States anyway. Now, we have some blocked assets.
But
the federal government has been holding
for
decades, and maybe
what Congress did not do was to touch executive immunity, execution immunity provisions that we're putting aside the practical concerns. We're going to prevent, as a legal matter, these agencies from having to cough up.
I think that 1611C is ambiguous about whether they were displacing 1610 or not. I think, as my friend pointed out, notwithstanding clauses often create this type of ambiguity, whether they're going to be, whether there's a negative implication or whether they're just belt and suspenders.
I don't buy that one.
And so we haven't taken a position on that. But as I'm saying, I think that it is quite common for there to be a mismatch between these two types of provisions. And I don't think when Congress was saying that it wanted these types of lawsuits to proceed and they wanted them to be a tool for foreign policy, that even if at the end of the day there wasn't going to be collection against actual Cuban property that was already in the United States, Cuban governmental property that was already in the United States, that doesn't mean that there isn't some power to having a federal judgment that says, look, Cuba is actually, people are trafficking in this expropriated property. There should be treble damages. This is something that people should be held accountable for. We haven't forgotten this. These are U.S. nationals whose property was wrongly expropriated. We want there to be something done about it, and we want there to be the poison pill that my colleague talked about earlier that would deter others from cooperating with the Cuban government.
Justice Gorsuch? Mr. Campbell?